Hello and welcome to Glasgow Loves EU. This evening we're interviewing Heather Burns of the Open Rights Group. Heather studied in George Washington University and the University of Strathclyde right here in Glasgow. She is writing the first ever book on understanding privacy, especially for web developers and designers. And nowadays she is a policy manager for the Open Rights Group, which promotes rights in the digital age. Her areas of expertise include digital rights, including freedom of expression, the right to privacy, and seeking effective regulators and regulatory standards. So hello, Heather, thanks for coming.
Hi, Jenny, my pleasure.
Okay, and this evening then we've got Bernd who'll be helping us on the IT side, and we've got Paul who'll be taking your questions on social media. So if you have any questions, you can just post them on Facebook and then we'll try and get to them. So first of all, Heather, if you could tell us about Open Rights Group and what you do.
Sure. So Open Rights Group, we are a digital rights campaigning organization, and we seek to help build a society where your rights to privacy and freedom of speech online are respected, protected, and fulfilled. We have over 20,000 engaged supporters across the UK, helping us to do the work we do every day, advocating for evidence-based policy guided by respect for fundamental human rights. My remit is policy manager, which means that I help to support our work on all of those issues in the policy sphere. That involves a lot of work on freedom of speech issues such as the online harms legislation. It involves the rights to privacy, such as the National Data Strategy. It involves a lot of work on international trade deals, as we're going to be talking about tonight. And I also have a remit for Scotland and all sorts of devolved digital rights issues in our Scottish context.
Okay, that sounds really interesting. So just in terms of Brexit then, so for now, GDPR obviously applies to the UK, and 75% of UK data flows are with the EU. So can you briefly explain how Brexit affects data flows with the EU?
So a lot of people think that when the UK left the European Union on the 31st of January and after the transition period, European data protection law doesn't apply anymore. That's not actually true. The European Data Protection Framework, which we know as GDPR, was actually placed into domestic legislation in 2018 as the Data Protection Act 2018. And that stays. That is not going anywhere. It is still the basic legal standard that we will continue to have after the transition period ends. The issue then is what becomes of that? And part of that is data protection adequacy. European privacy law, not just GDPR, but the Data Protection Directive of 95, which preceded that, holds that any country receiving European data, EU data, must have a data protection framework which is deemed adequate and equivalent to the European framework. GDPR, in the domestic context, as the Data Protection Act 2018, is at risk of being watered down and eroded, as it already has been in many aspects. So then that issue becomes, will we still be an adequate country to receive European data? And all indications right now are we will not receive that adequacy agreement.
Right. And so then after Brexit, so obviously the UK will be outside then GDPR, and the Information Commissioner's Office will no longer be part of the one-stop shop and the European Data Protection Board. So although the UK requested to retain these powers, the EU obviously rejected that idea because no third countries had kept those powers. So do you think the UK will then not be like a rule maker, but rather they'll be a rule taker, so they'll be kind of subject to whatever the EU decides then?
Well, that's absolutely it. The ICO did request to retain its membership on the EDPB. Well, let's back up a minute and do some definitions. Data protection law and privacy law in the UK is regulated by the Information Commissioner's Office, or the ICO. They are the privacy watchdog. When we were in the European Union, the ICO was a member of the EDPB, European Data Protection Board. That's a hard one to say, which is the umbrella organization of all the European member states' data regulators. We had a seat at the table. And a classic example of what's called cakeism, after we left the European Union, the ICO requested to retain its seat. You know, it wanted to have its cake and eat it too, retain its seat at a table it had chosen to leave. And that was turned down. So the ICO very much would like to continue to have a voice in European data protection affairs, but as you know, we're just basically considered the difficult X. So in addition to losing our seat at the table in things which impact us, the ICO, many of us would argue, has given up its seat domestically too on the things it can control. So we're not only a rule taker internationally, we're also having many of our data rights eroded domestically.
Yeah. Yeah, cakeism. I like that phrase. I think I'm going to use that in the
You're
future.
welcome to adopt it.
Yeah. So just in terms of adequacy decision, just getting into the nitty-gritty of it, it's that the commission will be kind of examining the internal legislation on human rights and surveillance and all that. So how concerned should we be regarding surveillance in the UK? So in terms of, you know, the Investigatory Powers Act, and how do you think, how will this affect the Commission's decision in terms of adequacy?
It absolutely will impact it. And there were judgments and rulings even before we started talking about the nitty gritty of what Brexit would mean for data protection several years ago, which ruled that those mass surveillance programs were incompatible with the fundamental human rights afforded to us as European citizens. So in a normal situation, our surveillance system alone would be an obstacle to any adequacy agreement, but it's actually one of several obstacles to an adequacy agreement. There are numerous other issues, including the ICO's failure to enforce, including some of the issues our Open Rights Group raised today about the Japan trade deal. That it's really quite mind-blowing how the situation's been allowed to get to this point where something as critical as our data protection adequacy is about to slip through our fingers, and nobody's really working on that. It's not fish.
Yeah, interesting. And so is it your view that there will be no right to data protection if the UK leaves the EU, if the UK doesn't retain the Charter of Human Rights, say, for example?
So the Charter of Fundamental Human Rights is just one half of that. The other half is the Data Protection Act 2018. Now, the thing to remember is that GDPR and the European data regime isn't just about a lot of paperwork and bureaucracy. It's about the fundamental rights we have over our data. The right to know what is done with our data, the right to know what data is held, who holds it, why they hold it, what rights we have over it. Can we obtain a copy? Can we correct any mistakes? Can we order whoever is holding the data to stop using it? Can we order them to delete it? All of those rights have been given to us in law through GDPR and the law which preceded it. The question now becomes, how much is the UK going to erode out of that and still claim they are compliant with both European data protection adequacy and with any standard of fundamental human rights? And we do risk a situation where it's babies in bathwater. Anything that came from Europe is bad, therefore we need to get rid of it, and we lose our basic rights over our data and our privacy in that process.
Yeah. And so in terms of then surveillance by US tech companies as well, and the potential of, you know, unprotected onward data transfers, will that become an issue?
That will absolutely become an issue because there's the surveillance, there's the sort of government mass surveillance, and then there's what we call surveillance capitalism. The data flowing about us to social media companies, to American companies, even as we speak. And what safeguards are we going to have over our data in a post-Brexit world where the United States, with its no federal privacy legislation, no data protection law, and a culture towards privacy, which often verges on contempt, is seen as the model to follow rather than to run away from.
Yeah, that's true. Yeah. And do you think that businesses are prepared for, say, for example, if there's a no deal Brexit? So in terms of data protection, like do they have, you know, say, for example, data protection officers in the EU, and have they put maybe, you know, the necessary clauses in place? So say, for example, standard contractual clauses or binding corporate rules, and maybe you could go into just explaining what those terms mean. And then, because I think to put these binding corporate rules in place, they cost like 250,000 and could take years to set up. So do you think the businesses are prepared for that?
I don't think they are, because these issues, we never had to consider these issues. These were always what ifs. And now they're on our doorstep. Just so everyone understands, an adequacy agreement is the process by which a country outside Europe, such as post-Brexit UK, will receive an agreement from the EU that, yes, your national data protection standards are equivalent to ours, and it is okay for data to flow back and forth like water. We don't have to check on that. If a country doesn't have that adequacy agreement, what they have to do is those things you talked about, those sort of duct tape workarounds, BCCs, which are binding contractual clauses, which are things big corporations use, standard contractual clauses, which is more for the everyday business owner and company. But then again, it's not just about the fine print in your contracts, which those things are. It's about your everyday data handling procedures. What are you doing with this data? How are you safeguarding, or what security measures do you have? What people have access to it? And people tend to look at all those issues, unfortunately, as you said, in the terms of those legalese things, the contracts, the issues. How much do we have to pay for a lawyer to rewrite all of our contracts? But it's the human rights and the privacy rights and the digital rights issues as well. So I don't believe people are really prepared, because they're not thinking about these things in terms of anything other than, oh God, I've got to go spend a lot of money on a lawyer. I've got to redo all my contracts, which, yes, they do. But there's a lot more at stake than just the fine print.
Yeah, I guess maybe for a lot of people, they're kind of abstract concepts that are kind of out there, and they don't really know how they actually apply in the real world.
Well, I mean, they shouldn't have ever had to know these things, because these things never should have been issues. Withdrawing from the only legal framework that we have ever known in the digital world and replacing it with a giant question mark is not something we should ever have had to do.
Yeah, that's true. Yeah. So then, in terms of elections, so obviously the UK government published the National Data Strategy recently. I don't know what your view is on that then.
So the National Data Strategy, it's a consultation that's out just now. It's not going to be a law. It's not a piece of legislation. It's more of a plan or a framework about how will we do data? How will government use public data? How will government incentivize private companies to use data? And this can all be very well and good and very altruistic. Yes, let's loosen up our data. Let's share more data within, as long as, it's protected, it's safe, it's not like personally identifiable. And that could be done very well. But then you read between the lines. And when I read the consultation from a policy role, what just jumps out at you is the ICO, which is the data protection regulator, is barely mentioned. They're mentioned so infrequently that I actually did a Control F find to count how many times they were. Who is mentioned in this document is the CDEI, which is the Center for Data Ethics and Innovation, which is a think tank. And from a policy perspective, reading between the lines, what that means is the National Data Strategy is seeking to move away from privacy and data protection as legal frameworks and to replace it with ethics frameworks. But as you know, at the end of the day, an ethical code of practice does not have your back, and it does not have a company's back. Data protection and privacy law are what protects you, and at the end of the day, they're what protect a company as well. So I, along with many others, including pretty much everybody who reads that strategy, who knows what they're talking about, picks up on that this seems to be an effort to move us away from the legal protections, which include our privacy rights that we currently enjoy, towards a more sort of voluntary, self-regulatory, yes, I pledge I will be responsible with your data, which is as good as the paper it's printed on. So we're going to be making representations on those aspects of the national data strategy to make sure that what it isn't is actually an attempt to, again, erode our privacy rights with a happy face on a document.
And do you think when they say data, they use that word in the national data strategy, what do you think they're referring to? Like, what kind of data are you talking about?
So in some aspects, they're talking about big data. And you had to laugh at the example they used in the consultation document is the way we've used data in the pandemic. Now, some of the uses of data in the pandemic have not been anything to be proud of.
Yeah.
We've all heard about Excel spreadsheets and miscounts and the numbers needing to be changed. Now, yes, we are doing amazing things with big data. Yeah. And those things are helping people every day. But the pandemic has been a heck of a bad time for us to be figuring out these things and making mistakes as we go. And if we can't get it right when people's lives are at stake, how are we going to get it right for, they always like to use examples in these documents of helping people use their electricity more efficiently, which at the end of the day means switching suppliers. If we can't get saving people's lives right, what does it matter that we come up with new and innovative ways to download smart meter data? I really don't get that.
Yeah, that's a really good point, actually. Yeah, should we see, can we take any questions from social media? Is there anything come through?
Just one really, which was this question about adequacy. Do you think that this is then going to have a disproportionate effect on SMEs? And then a related question, thinking about the UK's done quite well in terms of having this kind of culture of startups. Is it then going to have an impact on that community, do you think?
Oh, absolutely. One of the things, one of the basic rules of dealing with policy and digital policy, and this is literally every day of my job, is policymakers think the web is Facebook and Google. They think that is the internet. Startups, SMEs, aren't even on their radar. And a lot of the legal and policy issues we deal with, a lot of policymakers don't understand that they impact SMEs. The online harms framework is the classic example of that. It's a piece of legislation tailored to go after Facebook, Twitter, and Google, which is going to hit every company that has a digital presence in the UK. So in the adequacy terms, what you get is policymakers thinking, oh, this will be fine because everyone has a legal department. Not every company has a legal department, much less one specialized in these, you're getting the impression, extremely niche specific contractual / data protection issues. Not everyone can afford to. And for really small businesses and startups, what they will do is they will just remove themselves from the European market. They will have to, get rid of their European customers or never expand there, because the compliance costs, not to be compliant with European law, but with domestic law, will be too much. Now, there are some, we do encounter policymakers who think that's great. You should do business here. You can expand to new markets. You can go do your business in the US. You can do your business elsewhere. But since when did governments start deciding where people's targets markets would be? You should be able to decide where you're going and not have to make that decision based on a policymaker thinking that everyone has a legal department like Facebook.
Yeah, excellent. Thank you. That's really interesting.
Yeah, that's really interesting. That's really informative. So it seems like businesses are going to be in a spot of bother in January. And then in terms of, say, so elections, what would the consequences be of, say, no robust, privacy protection legislation? Do you think it would exacerbate interference and targeted disinformation?
Well, we've just, it's incredible that we've witnessed the whole Cambridge Analytica scandal about data collection and targeting. I saw the Channel 4 expose just a few weeks ago about how for this election, not the previous one, this one, they were targeting minority communities by the street with intensely personal information about them. And we don't want to have that here. And there's a very interesting contradiction when you speak with certain conservative politicians who are very much like, yes, pro-Brexit, EU regulation, get rid of it. We should also legislate against political disinformation and electoral interference. And it's down to people like us to say, if you get rid of GDPR, you are opening the door to all that. You are literally opening the door to all the electoral interferences you want another piece of law to combat. Mm-hmm. So I am sensing a bit of pragmatism starting to surface amongst even conservatives, that you cannot just dump the European data protection and privacy framework out of spite because it came from Europe, without opening the Pandora's box of the very consequences you are trying to address in another context. None of us want to see an American-style electoral system where, you know, we all have friends who've been bombarded with calls and adverts and emails, extraordinarily personal. What is it that the Trump, both the Trump and even the Obama campaigns had like 5,000 data points on every single American? You know, that is not what we want here.
Horrifying. That's really, truly horrifying. Yeah. And there was an interesting article in The Guardian there where it speculates that after Brexit that the UK could be a tax haven and a data haven. And, you know, we all know Dominic Cummings described GDPR as horrific and idiotic. So he'd rather remove all the legal barriers and to exploiting data. But as the article went on to say, there are two types of countries that lack privacy legislation. There's underdeveloped and authoritarian. So you think it would be a privacy disaster then in terms of democracy in the UK?
I think, you know, we would end up in a very ugly middle between incompetent and authoritarian. That article that you refer to, the Carissa Veliz one, actually informed a lot of the work we did at Open Rights Group today on the Japan trade deal, because she put out this what if scenario about weakened UK data protection law, and a sort of duct tape adequacy decision could create a scenario where the UK becomes a data laundering hub, where we take data and sell it on and do horrible things with it outside a legal framework. And we actually found that already happening in the Japan trade deal. It will
Can you just expand a bit on that?
Yeah. So the UK has just concluded its first trade deal outside the European Union with Japan. And they were, you know, trumpeting this as a wonderful thing, pro-innovation, pro-growth, da, 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 da. Well, it's the job of people like ourselves at org and our team and our network to take an extraordinarily boring 800-page document, and in this case, a trade deal, and read every line of it with a highlighter to find literally the 3 or 4 paragraphs which traded away our digital rights. So we've discovered that there are clauses in the Japan trade deal which would allow European citizens' data and our data to flow from the UK to Japan to the United States as a sort of data washing laundry. Just why have to go through Europe and all those bureaucratic regulatory loopholes? You can just do it that way. So we've been very active today speaking with policymakers, just opening their eyes to the fact that, you know, this was not a drafting error. This was not an omission. This is a deliberate tactic to try to bypass European privacy law and the safeguards it affords our citizens. So to get back to the question, yes, you're absolutely right. These issues could, you could almost like take a drink every time a politician uses the phrase world leading. You know, the UK will be a world leading country in the ways we do things. And the point we're making is this is not the world leading you want the UK to be. You do not want us to be the global data laundering hub. So time to decide what they want to do. Do they want to just carry on with this Dominic Cummings like zealotry of GDPR bad, regulation is bad, get rid of it, and the price we pay for that is becoming a data laundering hub? Or do we want to have an honest, upfront discussion about what sort of data rights do we want to have, regardless of where they came from? And I don't think the national data strategy is that conversation just yet.
Wow, it sounds like there's really important work you're doing, so keep up the good work.
Thank you.
Yeah. Have you got any more questions? Social media coming through?
Not at the moment.
No. Okay.
That's
Okay.
because everyone now has a very bad headache.
Yeah, we're frantically Googling the data laundering. There was just one other question I had about the immigration exemption, because if you could firstly explain what that is, and then experts are saying that it could also affect the UK's chances of getting adequacy decisions. So if you could just take us through that for a few minutes.
So the immigration exemption, in plain English as possible, was a carve out of the Data Protection Act 2018, which allows so data about people with an immigration status does not have to have, they don't receive the same safeguards that they should have, and organizations holding that data are not obliged to protect it with the same safeguards. So it's as horrific as that. It's like your immigration status determines your privacy rights, which is completely wrong. And it also, it's you can just feel that sort of heavy-handed Theresa May, Priti Patel claw on businesses saying, you must report these migrants to us, regardless of any sort of status of theirs. So it is, and it should absolutely be an obstacle to adequacy, because that will impact many, many European citizens. We at Open Rights Group worked with the 3 million to challenge that exemption. And we are in frequent contact with the 3 million on these issues. But as I said a few questions ago, it is just one of many, many things in the way of adequacy. And we have, 6-7 weeks to sort these issues? And I don't think we will.
Yeah. And do you think that it might lead to kind of victimization, discrimination, increase in, xenophobia?
Yeah, you have to view it in context of other things. My colleague Sadia, who is our immigration policy manager, has written a just wrenching blog about, there are people who are afraid to download the COVID apps because they're migrants, and they have no guarantee that their test and trace data will somehow not be linked to other things. And as far as they're concerned, it's a giant snooping and surveillance app, because they don't have the same protections that you and I do, simply because of their immigration status. And in a public health emergency, they are basically having to opt themselves out of the public health system for their own protection. And that's already the horrific consequences of the immigration exemption in action.
Right, that's fascinating. It's really that has consequences for the entire population. In terms of a pandemic, definitely. Yeah. And do you think for the ordinary citizens, what is the best way for them to protect themselves and their own personal data then going forward, say from January?
I don't expect people to be lawyers. You shouldn't have to be. I'm not. But the thing to remember is that you have rights. You have rights over your data. And that's whether that data is held by a government body or a social media company or a local business where you have an account. And those rights are yours, both as human rights, and they are your rights by law. And whatever happens to data protection law after the end of the transition period, we all need to fight to ensure that those rights are retained and enforced by a regulator, and not just by empty promises and codes of conduct. And we all need to be prepared to fight to defend those rights, and that they are not thrown out babies in bathwater because they happen to come to us from Europe.
Okay, that's really, thanks, but that's good advice. I think we're kind of running out of time. Is there any more questions from social media?
Yeah, so just one question about this idea of us becoming possibly sort of a data laundering hub, and thinking about what kind of data that might involve. So one obvious area of concern is about health data. And I just wondered what your views are on what potentially may go wrong there, because obviously we've already had a situation where the NHS has sold large amounts of supposedly anonymized data to Google. So is there a concern that could become a much bigger, essentially, giveaway of very personal data?
this is where everything fits together. That is absolutely a concern we have raised. We do not have any explicit guarantees that NHS data could not be flowing via Japan to the US, especially in the context of private finance contracts. You know, when everything is outsourced and the name tag may stay NHS, but it's actually a private company. And those private finance contracts are so opaque and dense and sometimes held in confidentiality. You know, that's not a hypothetical. That will happen. Sorry, I didn't have a better, more optimistic answer for you. Yeah. But yeah, it's probably sounded like a very downbeat conversation, but these are the things which keep us going. You know, we get up now to bed every morning ready to fight these issues and fight your corner, and we will continue to do so.
Yeah, and that's a really serious issue. So yes, please continue. That's really appreciated.
Yeah, you're obviously doing like really, really vital work, and you know we'll appreciate it definitely. And you've given us a lot to think about. You have any closing comments yourself?
Please check out Open Rights Group and what we do. We are a membership and dues-based driven organization. You know, we don't accept, for obvious reasons, we don't accept corporate funding. So we rely on everyday people like you to fund our mission.
Okay, that's fabulous. Thank you so much for coming in.
I really appreciate
sharing
you inviting me. I enjoyed this. Thank you, Jenny.
Okay, great. That's great. Thanks very much.